This hearing is in the matter of case CFI 092-2021 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Trowers and Hamlins, LLP. Lead counsel is Mr. Harris Bohr. Thank you.
Yes, Mr. Bohr.
Good morning, my lord. Thank you for making time for us this morning. I don't know whether you've had an opportunity to read the skeleton arguments that we provided and look into some of the documents.
Yes, I've read the skeletons, I've read the affidavit, and I've read the affidavit and the witness statement. I haven't descended into any detail into the exhibits.
That's helpful, my lord. In that case, what I propose to do is take you to those. Before that, I thought I'd deal with the issue of jurisdiction, because that was an issue I don't know whether you've seen in the second, you would have seen in the second skeleton argument that the registry raised. I mean, we essentially have three propositions in relation to this. The first is that the DIFC courts have very broad jurisdiction in relation to the making of freezing injunctions. Which is different to the English court in the sense that the English court has the CJ, the Civil Judgments Act, which you'll be familiar with, which has terms such as expedience and the like. The terms that apply in the DIFC seem to be broader. So that's the first point. The second point is that in terms of, to the extent that a connection is needed, we say that there is sufficient connection in this case by virtue of the fact that there are assets in Dubai and the fact that this is an international fraud where courts will ordinarily view the connecting factor in a slightly different way than they would otherwise do. And the third point in relation to this is that we say there is a possibility the RDC. So I don't propose to do so unless you want me to.
You froze then, Mr. Bohr, on your third point.
Yes.
So far as connection is concerned, there's also that there are two defendants resident within the jurisdiction, it would appear. Is that right?
I don't believe they're registered. They're resident in the DIFC, but they are resident, we think, in the Dubai.
Okay. Okay. So
that's the closest.
In a sense, the connection depends almost entirely on conduit jurisdiction.
Almost entirely, and the almost is important because there is a statement in the in the affidavit to suggest that given the nature of the business of the defendants, it is likely that they'll have assets or accounts or money passing through the DIFC, but that's as far as it goes. But you're quite correct that it's almost reliant on the conduit point.
Yes, I mean the evidence of assets in the DIFC is very tenuous. It's, well, you might expect there to be because they're residents in Dubai and they've got lots of money, but that's about all it amounts.
That is, and we accept that.
Yeah. Okay. And your third point?
That was the third point. The third point was there is a possibility of assets in the DIFC, but we say no more than that. And you're correct in the way that you've characterized that. I don't know whether you caught me, but I did also mention the fraud point. In other words, that courts are ready to find connecting factors when they're fraud. But the other thing I said was, and I don't know whether you heard this, was that I'm happy to take you to the JAL and the court law and the rules. But I assume you're very familiar with that, and you won't want me to take you through to each of those. So with those points of jurisdiction, in that case, I will move then to the background and why we say we have a good arguable case, which also touches upon issues of jurisdiction. The matter, as you will appreciate, essentially involves a substantial family dispute between Musaed Al Saleh and Fawzi Al Saleh, who are brothers, and their respective families, going back to. UEL was established in 1983 Sandra Holding has 13.01% interest in UEL. That we don't have the most up-to-date register of members, but there is ample evidence that that's the case. And there's evidence from the winding up proceedings, evidence that's been put in before the US court. There's also an excerpt which refers to the date of 2016, which refers to 13.01%. So we don't believe there's any real dispute in relation to that. Fawzi was appointed as the managing director of UEL and was thereby given responsibility for the day-to-day operation of the company. UEL, as we said in the skeleton argument, is subject to a shareholders agreement and articles of association. The claimants claim that Fawzi has breached the terms of the shareholder agreement and the articles of association in numerous respects. I won't go into detail because this is all still background, but essentially we say that he's failed to hold general meetings, he's failed to provide transparency no responses. The last consolidated financial accounts that we say we've seen is from the 31st of December 1998. That's some time ago. We say that Fawzi has failed to ensure that there are 7 directors appointed to the company. We say that he's failed to resign as a director when he went bankrupt in 2002. And we say that he has not paid us or procured the payment to us of dividends for decades. So those are the general allegations.
Who, Mr. Board, are parties to the shareholders' agreement? I haven't looked at the shareholders' agreement at all.
Yes.
And one of the matters I want you to address at some point is not only the status of the status of Mr. Nouri in terms of locus standi as opposed to Sandra,
yes,
and what in English law might be called reflective loss principles.
Yes.
And I should say, Mr. Bohr, that from time to time
yes.
You're freezing. I don't know whether it's me or you.
I don't know. I've never experienced that problem before. And I'm in Chambers. I'm the only one here, so I can't imagine there being much demand on the broadband. So I'm not sure why that's happening, and I can't see anything happening from my side.
Okay, well, it may be my end, but there we are. I'll just have to wait for you if it happens again.
Okay, I'm grateful. I'll look out for that. The shareholders agreement is at C79, I believe. My numbering is slightly different. I think I need to add 2 for each number I give you, but C79 should be yours.
Bear with me a moment. It's not responding for a moment. Hold on. Come on. Sorry, I've got to reload the web page.
No problem, Manoj.
Come on. It's all being very unresponsive this morning.
That's unfortunate, my lord. I assume you have a hearing after this that you'd want to get to as well.
Don't worry, we'll get there. Carry on while I wait for it to come up. I'm on the.
Well, in answer to your question about who the party. In relation to the shareholder agreement, you asked who the parties are. So the parties are Yasmin Holding, Basma Holding, Sandra Holding, and various other companies, including of UEL, but also Fawzi Al Saleh as an individual as well. So he's individually a party.
That's what I see.
Yes, yeah. Nori does not seem to be a party to this.
No.
Yes.
Yeah, well, that's what you'd expect, isn't it? It's the holding companies plus.
Yes.
Policy. Yeah. Yes.
Yes.
Okay, go on.
Indeed. So what? Just mentioned that Fawzi Ahmed and others, it seems, have engaged in a fraud to remove assets from UEL. Including through a trust called the Booty Trust. And this is the main cause of action that we're relying upon in this application. The removal involves two transactions. One of them took place in 2014 in relation to assets of a subsidiary called Seapwit. And the second transaction, it took place in 2015 in relation to a subsidiary called Metanic. And we say that Fawzi caused UEL's wholly owned subsidiaries to dispose of shares and or assets of these two entities. Seapwit, the value of the transaction that we can see given is $24.8 million US dollars. Metanic's value is $19 million US dollars or thereabout. So the entire transaction was said to be worth about 43.6 million US dollars. However, UEL does not seem to have received any consideration. So the purchase agreements one sees at C317. I don't know whether you've got the bundle working yet.
Yeah.
So it'll be C319, sorry, in your bundle.
Yes.
And you can see this is the Seapwit, the 12th of September 2014, and you can see the value of the sale of assets there. And the date of this transaction is worth noting because you'll see that the actual transfers that are said to relate to this predate this transaction. If you turn to page 324, you can see a deed of trust dated June 2013, which relates to ASPTC. And this is the trustee of the Booty Trust, which is the trust who apparently purchased the assets.
And where is ASPTC incorporated?
I believe that is incorporated in the BVI.
Yeah.
And it states as much on that document at 326 of your bundle.
Yeah, it's keeping me out for the moment, but yes.
So although there isn't any consideration, what seems to have happened is that Fawzi seems to have attempted to create a paper trail by transferring monies between Kuwaiti companies and UEL's subsidiaries. But actually, no consideration seems to have actually ended up in UEL. And we'll look at that in more detail momentarily. In 2016, so that's a year after the Metternich transaction, Fawzi then seems to take steps to protect himself by having D2's, that's Nuri's son, have Nuri sign a deed of indemnity. And you can see that at page 127 of the bundle.
Yeah.
Actually, 127 is the covering email from Wilmer Hale, which says it. Hello, Musaed. Subsequent Holdings Limited, a company wholly owned by UEL, is in the process of being liquidated. And what Nuri says is that this is the first that he heard about this. This company was being liquidated. And then it says, in order to proceed, we require signature by UEL shareholders of a deed of indemnity. Now, what's strange about this deed of indemnity is that when one looks at paragraph 5, one sees that it doesn't just seek to indemnify the liquidators of Sepuit, but it seeks to indemnify the company of the company hereby confirm that such amounts are not due to or from third parties and have been pardoned and waived. And we say that when we look at this now, in terms of what we know, what was happening is that Fawzi was attempting to cover his tracks. He knew that this transaction was unlawful and that amounts hadn't gone into UEL. This is way after the transaction, so we say. And he's trying to have the shareholders offer an indemnity to the company in relation to this. And unsurprisingly, Nuri didn't sign this. But that's not the end of the matter, because in February 2017, Fawzi makes another attempt to cover the fraud. And this time by having KPMG write a report on the transaction. And both the engagement and report support, we say, the claimant's case. If you go to page 359, C359, you find the engagement letter. And the second paragraph I think the judge has frozen.
I'm here and I can hear you.
Ah, okay, you hadn't. Sorry. Do you have the page 359?
I do have 359. Yep.
Yes. So the second paragraph says we will apply the following agreed upon procedures to the Sepuit holdings, and then it goes into what those procedures are. And what we say is that actually what happened was Fawzi approached KPMG. They agreed that KPMG would do a very high level analysis of this transaction, which essentially they were told simply to match amounts. In other words, the amount of consideration that should have been paid for these transactions to amounts that had gone out of various companies. But that's it. It's not a report, an audit report that they were being asked to produce. And as I say, you can see that from that first sentence of the second paragraph. And then they, in fact, at 360, you can see after the numbered paragraphs, it says at the inclusion of the engagement, Coebin Capital, which is a subsidiary or was a subsidiary of UEL, agrees to supply us with a representation letter that, among other things, it will confirm management's responsibility for the sufficiency of the agreed upon procedures. And that same sentence or sentiment is expressed in the paragraph below. The sufficiency of the procedures is solely the responsibility of the specified users of the report.
Mm-hmm.
And they make it clear, the next paragraph, first line, because the agreed upon procedures referred to above do not constitute an audit. And so, in other words, we say that this is all being procured to create an impression that this is all above board, when in fact it isn't at all. And one also would question, you know, the date on the top of the letter, 2017, why a report is needed from KPMG so many years after the transactions. Now, the actual report is at page 365 and onwards. And what's most important about this is the table at 370. Because what you can see here is that exactly what KPMG are doing. They have certain transactions going out from a company, Uni Asia, and these all are subsidiaries of UEL, and they're going to Kuwaiti companies, and these are companies in the Kuwait case, Cubic, First Services, and you can see they reach a total here of 22 million in relation to the CPRIT. And then on the next page, you can see there's another table in relation to the Metanic transaction, where they're then matching the transfers to the purchase price in the transaction documents. But what's strange here, firstly, is the fact that the companies, it's not clear why UEL subsidiaries are paying Kuwaiti companies for assets which actually belong to UEL or their subsidiaries, why the money is going that way. It's also not clear why money is being paid to these Kuwaiti companies when it's the Budi Trust, which is meant to be purchasing the assets or the shares. It's also not clear why these transfers of money take place in 2011, 2012, and 2013 in relation to the CPWIC transaction, for example, when we've seen that transaction takes place in 2014. The agreements seems to only have been signed then. And that's all, we say, very strange. And more than strange, of course, we say that this shows the nature of the fraud that's taking place.
Yes.
Now, the director of Cubic, Cubin, is called. There's a director called John Snow, and he is deposed at. You can see the deposition documents at C778. It actually starts a few pages before, but the reference I just gave you is the one that I want to take you to, because he was asked about the KPMG retainer. And if you should have a transcript on that page, and you can see in the middle of page 55 of the transcript, he's asked the question, what is your understanding of this particular project that KPMG agreed to undertake? And he says, well, it's in keeping with the description that there were certain procedures that we asked them to perform to validate or to attest to the transaction. So that goes to the point that we said before, that KPMG are simply being asked to validate something, but it's the management who are telling them what to do. And so he was asked, how do you determine what the procedures are? And then he says, it's Fawzi. I just agreed on what was with KPMG's input. That would be what would make the most sense in terms of not verifying. So those are important as not verifying, but just supporting the transaction. And then he was pushed on this, page 56, you don't have to read all of that. Page 57, he talks about he was asked about the certain procedures. And then he's asked the question, I'm presuming the agreement is the result of communications you had with Fawzi. He says, sure. And then I just want to understand what those communications were. And he says they were fairly limited. So again, we can see KPMG, fairly limited communications between Fawzi and KPMG, not asked to verify, but to do something different. And this discussion continues on page 58 of the transcript, where Mr. Snow says, and I'm looking now at lines 15 to 19 at page 58, Fawzi wanted to be sure that if there are any questions, any doubt about the integrity of the transactions, that we had a document to explain it. And we say that's exactly the point. If there are any doubts, why would there be doubts raised about this transaction years after it took place? Because the transaction was fraudulent, and we say Fawzi must have known that. And he wanted to have a document, exactly as it says here, to explain it. And then he talks about the word integrity there, but actually he backs away from that at page 60. He says, I don't want to use that word integrity. I think more evidence in supporting. And we say, as a matter of submission, that Mr. Snow would say that because he may know, perhaps, or at least doesn't want to suggest that it has to do with integrity, but merely the fact that what Fawzi was doing was covering his tracks. And he also confirms that at line 23 at page 60 of the transcript that he wasn't aware of anything that precipitated the desire to review these transactions. So he could give no explanation as to the background. On page 61 again at the top, he confirms that it was Fawzi. If you then turn to page 780 on the transcript, the discussion turns to the table, and he refers to a company, Uni Europe, which is shown in the table, and he says this is a wholly owned subsidiary of Universal Portfolio Holdings Limited, acronym UPHL, and he says that Fawzi owned it, and he says that it's owned 100% by Fawzi. Now, in fact, what we'll see, E&Y discover, that's the joint liquidators in UEL, is that the assets of UEL were moved to UPHL, I believe back in 2003. And UPHL is owned, as you can see from this, 100% by Fawzi. So essentially, he's moved all the assets away from UEL into UPHL. And then through this KPMG report, seems to have created the impression that UPHL has paid for assets. But the payments, as we've seen, have gone to Kuwait companies, which he also controls, not to UEL, in which our clients have a share. So that's the transcript. And essentially, Mr. Snow can't really assist much more with the table. So in terms of chronology, in April 2020, the Sandra holding applies to the Cayman courts to wind up the company, and E&Y, Ernst & Young, are appointed on the 9th of September. And on the 9th of September 2020, they produce a report, which is at C835. I mean, the report itself starts at 834, and you can see it was produced on the 9th of September 2020. And I'm not going to take you through every page of this, but I'm going to give you a few headline points. So at page 838, you can see there's a bullet point executive summary. The last two bullet points are important. The JOL's investigations have not identified any assets or bank accounts that are currently under the ownership or control of the company. So essentially, there's nothing left within this company at the time that E&Y gained control. Last bullet point, based on the JOL's initial investigations and review of the company's records received to date, the JOLs are of the opinion that there are certain transactions involving assets that may or may not still be legally owned by the company that require further investigation. So clearly, suspicions are being raised. If you go to 843, you can see a section headed details of the legal dispute between the members of the company. And the first line is important. In recent years, based on information available to the JOLs, it appears that significant divestments of assets from the company to BVI and corporate entities under the control of both Fawzi and his two children, Ahmed and Yasmin, may have taken place without any consideration having been received by the company and or onward distributions being paid to any of the company's shareholders. In 2003, there's reference to a reorganization plan. And you'll see the third paragraph there. It says, under the reorganization plan, the shareholders of the company were to receive shares in UPHL in proportion to their shareholding. So UPHL is that company that we saw Mr. Snow mentioned. And it's the subsidiaries of this company which were said to have paid for the assets. And what you could see from this is that the shareholders, which would include our Sandra Holding, our client, should have received a proportion in UPHL, this new company, but they didn't. The EY report goes on to say at this page 843 that according to the investigations conducted by JOLs, UPHL was dissolved in 2016 and that the sole shareholder at the time of dissolution was ASPTC, and that is the company we saw, the BVI company, which is the company which is the trustee of the Budi Trust in control, in Fawzi's control. Just moving on in the terms of the report, there's a reference at A48 to the KPMG report. So KPMG was jointly engaged by Quabin, so that's Mr. Snow's company, or the one he's a director of, or was a director of, and the company to perform a review of payments purportedly made in consideration. And what EY says that they were unable to obtain from KPMG the books and records provided by the parties in support as approval for their release has not been granted by Quabin. The JOLs will continue to make efforts to recover this important information. So EY are struggling to get information from KPMG. There's a reference to UPHL, just for your information, at 850 of the report, and to Uni Asia, which is subsidiaries we saw payments going out of. At 856, there's a series of bullet points dealing with correspondence initiated by the JOLs. And the first bullet point says that the JOLs wrote to Fawzi in his capacity as the sole director of the company on the 21st of July 2020, and there's various other dates there, not that long ago. At the date of this report, the JOLs have received no response. So again, you have an individual who's got lots of questions to answer, but is not answering at all, according to that bullet point at least. At 858, there's a reference to the recommended next steps. Again, you have at the second paragraph, the JOLs identify that they haven't found any assets or bank accounts under the ownership or control of the company. They say at 5.1, first paragraph, that the Metanic and CPIT transactions require investigation because the ultimate beneficiaries of the proceeds of the transaction are unclear. And there's a point here, and that is that not only have the assets, the CPIT and Metanic assets disappeared from UEL, but the beneficiaries of the proceeds are unclear. And what we say is it looks like monies actually went out of subsidiaries of UEL. So it's a double hit, potentially. In other words, money's been paid out, but no, and the assets have gone from the same entities or same overall group. And then you have a description here of the transfer of assets to UPHL, which we've seen mentioned before. I'm looking at the footer page 858.
Yeah.
And then it's over the page at 859, just the transactions that require further investigation have been identified. And there's lots of use of the word purported here, because clearly E&Y can't find the documents to back any of this up. And the last line is telling the JOLs would expect to see movements from the company's bank accounts in respect to these distributions. There's no record of any further dividends being declared by the company for the benefit of the members since April 1987, which is precisely what Mr. What Nouri's affidavit suggests.
Yes.
So then one asks the question, well, maybe Fawzi has an explanation. Well, we've seen that EY haven't got any proper explanation from him. What Mr. Nouri says in his affidavit is that he's been seeking clarity in relation to the running of this company and subsidiaries for years and years. There are documents which I won't take you to. They're mentioned in my skeleton argument, but C05, C107, C113, C115. But in terms of response, one letter which is interesting, particularly, is one at C484.
Sorry, C484.
That's 48. Sorry, it's 4. Yes, 484. Yes.
Yeah. Okay.
So this is a letter from Fawzi, which I'm told on instruction is a response to the letter on the pages before, which starts at 481, which is from Ogier, which was actually sent by Wilmer Hale, but you know, the cover letter was from Wilmer Hale, but actually attached the Ogier letter, who were acting in the winding up proceedings. And this letter is quite a long letter. We won't go through it all. Details many of the points that I've raised this morning in terms of the non-compliance with the shareholders agreement and the articles of association. Most importantly, you can see at 482 in the middle paragraph a reference to the two related party transactions, which involved the purported sale of tens of millions of dollars worth of UAL's assets to ACPTC, the trustee of the Booty Trust. And then you can see the allegations in relation to the beneficiaries of the trust. And it says this discovery, coupled with Fawzi's refusal to provide information regarding UL's finances, has caused our client considerable concern, not least because it has not received any dividends or distribution from UL following the sale. And there's reference also to the KPMG report at the foot of the letter. There's reference also to Mr. Snow and his deposition at page 483 at the top, and reference to allegations of breach of fiduciary duties and the like. So this is so turning back then or forward to the letter from Fawzi at 484. This is his response to all of this. He just simply says that the claims that you've raised in your letter are baseless and unsubstantiated. Well, we've seen that that's not true. There is a lot of reason for concern, to put it extremely mildly, if not information which points to outright fraud. So that's incorrect. And he goes on to say at paragraph 2, the reference claims allegations obviously negate the terms and conditions clearly laid down in the shareholders agreement. And he then suggests that back in 1996, the shareholders unanimously appointed himself and granted him the full power and authority to restructure and reorganize the assets. And as a result, a decision and steps were then taken to liquidate and repatriate all the investments held through Yale to Kuwait and other countries. But he doesn't say or explain why, in fact, Sandra has received no benefit for that, if that is indeed correct. And that's it. That's really the extent. I mean, it goes on, the letter goes on a few lines onto page 485, but that's all he says. And we say that's no explanation at all. And so on that basis, my clients started proceedings. Firstly, as I say, they applied to wind up the company. That has been wound up. There was a hearing on Thursday, and that winding up has now been recognized by the US, the courts in the United States. But they have also started several proceedings, including the Kuwait proceedings with capital K, capital P, the one that we're relying on today. And we say that is a damages claim. Now, you asked the question about reflective loss. And our point simply is that that concept doesn't apply in Kuwait. It's as simple as that. We say in Kuwait, a shareholder who has had his shares, the value of his shares damaged, or indeed a beneficial owner of a shareholder who suffered a loss by virtue of a fraud, is entitled to claim in relation to that. And the reflective loss principle would not apply. There's no fully fledged concept in the way that there is in England or indeed the DAFC.
Well, that doesn't surprise me. It doesn't surprise me at all. But
yes.
Do I have any evidence about that?
The only evidence, it's very difficult to produce evidence because the Kuwaiti, it's a negative, and the Kuwaiti lawyers wouldn't be familiar with it, which only goes to show that there's no concept. But what we would say as a matter of submission is if there was something which was so obvious, they would have addressed that in the outset when starting their claim, and they would have explained it in their evidence to the extent that that's a barrier to the claim. It doesn't appear to be a barrier, and certainly we say in relation to the initial application for an injunction, this shouldn't be a concern for the court. To the extent there is a reflective loss principle in Kuwait, which we say there isn't, then certainly Fawzi can come and explain that and why that would help him on the return date from this application, after this application. And that's really the short answer in relation to that.
Yes. Well, I'm entirely satisfied you've got a good arguable case or issue to be tried or whatever the relevant test is in this context.
Yes. Well, in that case, I'll move on to risk of dissipation. In a sense, I'll be repeating myself, so I can really summarize that very briefly. I mean, as I've said in the skeleton,
I don't think I need you to go there. It's quite plain from the affidavit evidence. You know, if this claim is well founded, then there's an obvious risk of dissipation.
Yes. In that case, I'll jump over that section and simply make the point about all the defendants, because the defendants may say, I need to be careful of full and frank, that why injunct us, why not just injunct Fawzi? And that's dealt with in some detail in Nuri's affidavit at paragraph 5.11. And Fawzi is the family patriarch, says Nuri, and it's clear from the evidence that in support of the affidavit, he's the primary orchestrator of the fraud. Ahmed, his son, has assisted his father in the fraud and also a beneficiary under the Budi Trust. Yasmin, we've seen, is a beneficiary under the trust. And then we're left with Farah, who's Ahmed's wife. And what Nuri says is that she is likely to hold assets on behalf of Ahmed and potentially also other defendants. And he also makes the point that the family operates as a group, with Ahmed, Yasmin, and Farah historically taking their lead in instructions from Fawzi. And we say that evidence makes sense in the context of what we've seen. It makes sense if someone's committing a fraud to want to use family members. It makes a sense in a culture where the family a close-knit family work together on financial dealings. And we say that's certainly sufficient in terms of arguability to make them party to this order at this stage, this point in time. And with that, then we have the just and convenient. We say, given the nature of the fraud, we say it's certainly just and convenient to make the order. There's an undertaking in damages. We say that's covered off. The amount of the order is one, again, having being mindful of the full and frank. I mean, the order that we're seeking is 43.6 million, which is the amount, the value attributed to the assets that were taken out of UEL. But the point there is that that's the value that's attributed to it on the purchase documents. We don't know how accurate they are. It may be that amount is much more than that as a matter of submission. That's number one. Number two, as we've seen from the KPMG report, not only do assets seem to leave UEL, but there are payments of 43.6 million or thereabouts, which aren't really explained. What those payments going out from 2011 to 2013 that we've looked at, and later payments, that UPHL is an entity in which Sandra Holding ought to have an interest, but hasn't been given an interest. So that's another slug of money.
I'm not really understanding this, Mr. Ball. Yes. This is paragraph 314 of your skeleton.
Yes.
And I put a question mark by there.
Yes.
And I have two questions.
You're right to, my lord. Yes.
I have two questions really in relation to this. One is, on the face of it, we're looking at 13.1% of whatever the figure is that's disappeared.
Yes.
Which is what's that, about a sixth or something, is it?
Yes, I think it's like 5.6 or something, 5.7
yeah,
million.
something like that.
Yeah.
So, and the second is, I don't quite understand why there's a potential doubling up, so to speak, in 3.4. I take it a misprint in the second sentence, which should refer to 43.6 again.
Yes, probably. Yes. So let me deal with that. We saw in the KPMG report a table. I can take you back to it if you like, but it is a table of payments, and those payments were from subsidiaries of UEL going out to Kuwaiti companies. The subsidiaries of UEL, that they were subsidiaries of UPHL. That's the company that we've seen where all the assets of UEL were moved into in 2003, and which, as we've seen, as Mr. Snow confirmed, is owned, and also UNY is owned by, or was owned by, Fawzi 100%. So just to be clear, this UPHL, which is owned by Fawzi, or was owned by Fawzi as, totally, Sandra Holding was meant to have an interest in that. So when amounts are being paid out of UPHL or its subsidiaries for no consideration, because they weren't receiving anything in return, it seems, that is an indirect loss to Sandra Holding. It's a loss of monies which would have been part of the value of its shares. So that's one element of loss. The second element is that these assets, the assets of Seepwit and Metternich, went out of UEL. And so those assets were no longer within UEL. That is a second loss. And both those seem to amount to a value of 43.6. In other words, the actual cash amounts transferred seem to come to 43.6. That's what KPMG are saying. And the actual assets, the value ascribed to them in the purchase documents, is 43.6. And that's why the skeleton argument picks up on that and says that there's a doubling of loss.
But it's the same figure, though, isn't it? I mean, it's not as if there are two lots of 43.6, is it?
Well, we don't know the full story, and I need to stress that. But when the figures in the KPMG report talk about payment of consideration, that's the impression that's being created, which suggests that that's actual cash that's being moved across. Because KPMG's job was to create the impression that money had been paid for assets, not just that assets had moved. So when the figures given in the KPMG report, we say are cash figures. And so that is actual money going out of subsidiaries. That is just self-standing, because those companies, these UPHL subsidiaries shown on the KPMG report, did not, as far as we can see, receive any assets in return for payment of those monies. By the same token, Seepwit, which was a subsidiary of UEL, and Metternich, which is a subsidiary of UEL, the shares in Metternich and the assets of Seepwit went somewhere. To the Booty Trust. That's what the agreement suggests. And those are actual assets. They're not cash. And so we say that on the face of the documents, it does look like assets of actual cash has moved out of UPHL to create the impression that there's been a bona fide transaction. By the same token, assets have gone out of UPHL's subsidiaries, Seepwit, Metternich, and therefore there is a double loss.
It's 13.1% of 87.2 million.
That would be the correct if those figures were the end of it. But those figures, my lord, aren't necessarily the end of it. And I say necessarily because there needs to be further investigation. Because the other point, and I don't want to make this overcomplicated, but I'm being forced because by the nature of this fraud, is that you'll note from the KPMG report that the monies went out from a subsidiary of UEL into these Kuwaiti companies, in which actually our client was also meant to have an interest. And it does seem that some monies have gone out of those companies too. But I'm not going to belabor this point. That I mean, the essential point is that the amount of damages actually suffered is difficult to assess, because we have, as I say, prima facie evidence of a doubling up, that it's more like 86 million in relation to these transactions. We don't. The value of the transactions we only know from documents that are being produced, it seems, by the fraudsters. That's the second point. And if you look, and this is one document which we should go to, at 878 of the bundle, what you have there is a proof of debt in the winding up proceedings, which show losses of at least $100 million. Now, it's true that not all those losses relate to these transactions, and it's right that I point that out. But nevertheless, as we pointed out, there could well be substantially more losses than 43.6 million, and even indeed the 86 million. And so we say at this point, the first trial, the first hearing of the application, the court should be prepared or find that there is at least arguable case to put the maximum sum as 43.6 million or thereabouts, the figure that we've stated. Having regard to the difficulty in assessing the damages and also the evidence at C878 and the points that I've mentioned about the KPMG and the assets going out as well, the doubling up. I mean, you would also be aware that according to G at least on injunctions, party can apply for an injunction for the benefit of other people. And so if we're wrong about this, certainly there is a loss of 43.6 at the very least from the company, and that injunction will benefit others, and that shouldn't be a barrier to the court making an injunction, as I say, at least for the short time between now and the return date. Those are my submissions in relation to that.
Well, what are the other shareholders doing? I mean, as I understand it, these are the only two siblings left, but there are obviously grandchildren of the original Mr. Mohammed, I think it was.
Yes. This is purely on instruction, and my understanding is they're not doing anything, right, or much, I should say. I mean, I need to be careful, obviously I don't want to give evidence, but I haven't seen anything which suggests that they're being active at all. And in fact, in the EY report, there is a statement that the creditors meeting wasn't quorate. And it may be, we don't know, but I don't know, my lord, that they're not participating in the winding up in any real way either. So we just don't know. And it may be, in fact, that they have received some dividends, although the EY report suggests that no dividends were paid out. But we don't know. And there's clearly a lot more investigation to be done, and as I say, some uncertainty. And I do think that we as applicants need to be slightly careful about preempting the outcome.
My problem is this. My problem is this, Mr. Boris. There's a proof of debt that talks about 100 million.
Yes.
You've talked about two lots of 43.6 million. Mm-hmm. You're very frank about there being a lot of unknowns, whether they are known unknowns or unknown unknowns. I'm not quite sure, but the real problem is, is it simply a matter of speculation as to what the figure ought to be? Particularly, as I say, what one's looking at least prima facie, is 13.1% of whatever the right figure is.
Yes.
Whatever the figure is that has disappeared. I mean, there's perfectly adequate evidence of dissipation, and on the face of it, it looks like 2 times 43.6.
Yes.
But your interest is only in 13.1% of that, which is about 12 million or thereabouts, I think.
Yes.
And so my problem is where does one properly and rightly set the limit for any freezing injunction?
Yes, my lord, I appreciate that issue, and I fairly acknowledge that it is an issue. I wouldn't say it's entirely speculative, but there is a degree of speculation. I have to accept that. But I would say that in terms of where the justice lies, we say that that you have a figure of 43.6, which is repeated again and again in all of the documents.
Yeah.
I do think the argument about 43.6 is reasonably arguable, at least in what we know. And we do know, and there is repeated comments in the documents, including in the EY report, that dividends haven't been paid for a very long time, and you've seen the proof of debt. And we say the court, at the initial stages of making injunction, can say that there are difficulties in quantification. Those difficulties, as we've seen, are due to the fact that Fawzi and indeed others, and I won't name them, have not provided full information. And if in fact the defendants, particularly Fawzi or Ahmed, had been forthright and explained exactly what is being removed, exactly the value of these companies, exactly the amount of dividends that they've taken compared to the amount they haven't given to us, then we would be in a strong situation. But we haven't been, and that's the situation of the defendants making. And I would submit that the court can see a proof of debt of 100 million and say that is speculative, but I'm going to go somewhere, halfway. I'm going to go halfway in relation to that. The figure of 43.6 million is being stated in numerous places. I can see there may well be more than that, double that amount, and therefore, even though 13.01% is stated, it may be of a much higher number, and therefore, for now, I'm content until the return date to make an order in relation to the 43.6 million, but we will hear arguments about that. And it's fair that Fawzi has a chance to come and say, actually, it's not 43.6, it should be 6 or 12. I mean, we would say the justice of the matter.
I understand the no harm done point, so to speak,
yes.
But that doesn't seem to me entirely principled. I mean, what's interesting to me is that there's a proof of debt for 100 million.
Yes.
And presumably, there's a basis for that.
Yes.
Quite how one gets to it, I'm not quite sure. Just looking at the proof of debt.
Well, it doesn't say on the proof of debt, but one could imagine that if dividends are not being paid from 1997 to 2021, that could add up to quite a large amount.
Yes.
I mean, that really is my only point. I mean, the court either accepts the proof of debt evidence, I suppose, based on what you said, and rather than the no harm done, your lordship is correct that that's not a basis in and of itself, accepts the proof of debt and the lack of clarity given, and saying the 43.6 that's justifiable now, or makes an order for a lesser amount, say 12 million. But my lord, I can't help you any more than I've done already in relation to that.
Yes, well, the company is valued at 166 million in 1999.
Yes.
According to the proof of debt.
Yes. And there are accounts to that effect as well, my lord.
Yeah, that's as big as it goes, is it?
I think so.
And 13.1% of 166 million is?
If I can interject, I've just worked out on the calculator, it's 21.75 million.
Thank you very much, somebody, whoever that is.
That's Mr. Schauder, my mathematical instructing solicitor. The figures I came to is 21.6, but Mr. Schauder may well be right.
It's 20 something, isn't it?
Yes.
Well, all right. Let's come back to the figure in a moment. I've got. Can I just run through a number of my questions to make sure that you've covered them? The first is the quantum. Second is locker standby. Cause of action. How's it working? Kuwait? Yes, we dealt with all that. Risk of dissipation. Assets in the DIFC. Utility, yes, depends on conduit. connection, international fraud. Yes, so now we come, in a sense, to the nitty-gritty. You're looking for a return date. Again, I appreciate you don't know what's going to happen, but what's your best guess as to whether there'll be any response at all?
My instructions are, I believe they haven't responded substantively to the Cayman proceedings. They did not, as I understand, unless Mr. Shouter tells me differently, appear at the hearing last week. They have, it seems, engaged in some of the Kuwaiti proceedings, but not, I understand, the Kuwait, capital K, capital P proceedings, the one that were the subject of these proceedings, this application. So I would say their response has been patchy, and on some of the very big issues, they haven't responded at all. And certainly their responses haven't been adequate, I've seen. So what are the chances they'll come? I guess it will depend how inconvenient the injunction is for them, and their asset situation, and how much they've, they think they need to comply, and all the rest of it.
Yes. And I failed to pick up whether there is a figure claimed in the Kuwaiti proceedings.
There isn't. There's mention in the Kuwaiti proceedings of 43.6, but that's in relation to assets removed. But the way that the Kuwaiti proceedings work, being a civil jurisdiction, is that an expert gets appointed as a preliminary. And so that the expert's role is really to look into the transactions and to investigate those. And that, it is said on the actual statement of claim, should give rise to a figure.
Yes, well, I'm fairly familiar with that as a
yes
process in many Middle Eastern countries.
Yes,
yes, I see.
I've just been told. Oh, well, I'll come back to this later. It's relevant to the amount. But
well, I mean, it's relevant in this sense because your claim form and so on is basically simply a Part 8 claim form in relation to foreign proceedings, isn't it?
Yes.
So that I don't get any assistance from your claim form. I tell you, at present, Mr. Ball, and
yes,
you can seek to persuade me otherwise, but at present, I can't see that I can realistically give you an injunction for more than the 21.75 in Mr. Scholar's calculation, plus a bit for interest and costs, whatever that might come to. Of course, if there's compliance by the defendants and they produce information about assets, then there's room for variation, I suppose, upwards or downwards. Upwards may be a problem because assets may have gone, but I can't quite bring myself to see, when you're talking about 13.1% of whatever the figure is, how we can be looking at more than that figure of 21.75.
Yeah,
13.1 of 72 odd million is a good bit less.
Yes.
And well, that's a see how it goes point then. I mean, if they ignore the injunction, if they pay no attention whatsoever to the disclosure obligations and so on and so forth, then you're going to be chasing money around the world, no doubt.
Yes. I mean, yes. I mean, really two points on that. The first is, I think I've given you my best arguments in the sense that the proof of debt seems to be the best. I am also told by WhatsApp from my instructed solicitor that there are actually accounts dated from 2000, which are 184 million. So when we can redo the calculation, that gives a little bit more, but the principle remains the same.
But I think that's as high as I can go. I think
yes.
I don't really see how I can do more than 13.1% of whatever the right figure is.
Yes. Well,
and I'm perfectly happy to listen to the current values or best estimates of current value.
Yes. Well, I haven't got any further arguments to make, apart from the fact that the accounts, even if we're looking at the 2000 accounts, that's 20 21 years ago, and so if values go up, you'd assume it to be higher. But I appreciate the predicament that you're in. The only other point is that if it turns out the amounts are a lot higher, then we won't be secured. But it's the point you make that this could be thrashed out at a return date potentially also has some weight. So, my lord, it is what it is.
Right. Well, let Mr. Scholar do his calculation on 13.1% of his best figure.
So, if I can read you the figure, the 2000 valuation is 184,247,144.
Yeah.
13.1% of that is 24,136,375.9.
Well, if we then allow for, let's say, 4 or 5% a year. So if we take the 184 million, that's 2,000, is it?
Yes.
Yes.
So we've got 20 years worth at 4%, let's say.
I'm afraid to say, sir, you are stretching the limits of my math skills, requiring me to work that one out. It may be best on that if we.
Well, if you simply take 180% times 184 million, you've done much better, and you're getting pretty close to 43, I would guess.
I think that's right, sir. Would it be best if we worked that figure out after the hearing?
I'd much rather do it now. Let me just. Okay. I can keep myself. We're going to talk in round numbers in any event. So
184,247,144, and then if we say, are we saying growth at 5% of that times 20 years?
Well, I was going to. If you'd say at 5%, you've got 100% straight away. So that takes you to 300 and whatever it is, 368, isn't it?
Sorry, sir. How did you get to 368?
184 times 2.
Oh, times 2. Okay.
Because it's
yes, exactly. So that's 368. 494,288.
So what's 368 times 13.1%?
It comes to 47.8 million. Or 37.9 million.
I've got 48. Right. So 368,494,288. 13.1% of that is 48,272,751.7.
Well, there we are, Mr. Bors. You've got an independent basis for your 43.6, and yes. I'm prepared to give you an injunction that goes to 45 million.
Well, I'm grateful, and I just wish I'd thought of that myself, my lord.
Well, it's one's got to talk in round numbers here because yes. one simply doesn't know. But and as you say, in a sense, from your point of view, it's safer to go high. And if they come back and say, "Don't be silly, it's only 6 million," then they can come back and say that.
Exactly, my lord.
All right. Fortification undertaking is the next question, Mr. Bors.
Yes. Well, he's given a bare undertaking at the moment. We say that should be sufficient until a return date. And at that point, the other side may wish to have it fortified, and we appreciate that, and that needs to be dealt with.
What's the potential losses that could occur in relation to this?
It's very hard to know. It's very hard to know because we have so little insight into his asset position, and whether he has lots more money than the money that's being frozen. We just don't know. Is the answer to that? It's all very unknown.
And what sort of fortification could you offer?
I'd need to take instructions on that. My solicitors have just heard that question, so if they could.
I mean, I take it that that Mr. Nouri is a man of some substance.
That's what I understand, and I understand that. And so again, if that's not correct, my solicitors will tell me. But I understand that he is a man of substance.
I mean, I think you'd have to be a man of substance to let this thing go for 25 years or whatever.
Yes, I think that's a fair. He is a man of considerable substance, is what I'm being told.
And where does he have assets?
Again, if my solicitors could let me have an answer to that.
Well, I think I need to know the answers to that. But
in Kuwait and Switzerland.
Right.
At a minimum.
All right, two more questions. What other variations are there from the standard form?
There is one that I've made, but I'd be inclined to suggest not. I mean, I can understand. I should say I could understand if you say no at this point in time, but I'll tell you why. The only real one that I've made is to say that we have permission to enforce the order in onshore Dubai and Kuwait, the UK, France, and USA, because that's where we've identified assets.
Yes.
And then, but nowhere else without the permission of the court. So that's the one difference.
And what's the essential principle which I have to apply in that context? The normal thing is no enforcement outside DIFC and Dubai.
Yes.
Without permission of the court. So why should I be allowing it in relation to any of the other jurisdictions?
The France was put in because
well, I've seen your evidence.
Yes. And in relation to also writing to French banks as well. That's why that was put in. The US was added because of the assets there, but I understand the point.
What's the principle which I meant to be applied to?
I have done this before. I just can't recall, unfortunately. I think the issue is whether, in fact, it's all to be overly abusive and vexatious and cut across what's going on elsewhere. I apologize, man. I should have really looked at this beforehand.
Well, you've got some proceedings in the US, but that's essentially the winding up, as I understand it.
Yes,
there's no proceedings in the UK or France that matter stand.
No.
All right. Okay, the last question is service by alternative means.
Yes.
Now, evidently, you need to give notice of the injunction.
Yes.
And so on, by alternative means, but service?
Well, we can't. The individuals concerned seem to move around a lot. This is an international matter. There are cases in various different places. They're well lawyered, or have been in the past at least, and therefore we say that in terms of efficiency, this is the right way to go. We would submit, at least again until the return date. If they want to come back and say that actually they should be served in person at a particular address, they can provide that address to the court. But at the moment we don't have this.
Efficiency is one thing, but that isn't the basis for giving leave for alternative service. I'm entirely with you on efficiency, obviously, but let me just remind myself what the rules are on alternative service. The test is some form of impracticability, isn't it?
Yes. Well, I would submit it is impractical at the moment to locate exactly where they are, and these documents should be served, and where the defendants are living, particularly in circumstances where they're not providing information, or indeed appropriately responding to proceedings, albeit different proceedings, to the ones that the order's being made in support of. And so we do say that the impracticability test is met in this case.
Good reason is the word used in 931 of the rules, where there is good reason to authorize service by a method.
Well, we would say there is good reason in this case, especially as an injunction situation in a fraud case, where things need to be dealt with. And I use the word efficiency, but I think that is a good reason in this particular circumstances.
Where are they resident or domiciled, so far as you know?
We believe that some have moved from Kuwait, and there is a reference to them being in Dubai, onshore Dubai, in the
well, that's the
statement.
son. That's the son.
That's the son. Yes. So the others. Let me just check my. I don't think we have good information. Fawzi is in Kuwait, and Ahmed and Farah are in Dubai.
And service in Kuwait would be by what method? Diplomatic stuff or what?
Again, I don't have information, but I can see my solicitors typing, so there may be some information coming on that. I don't have information on that, but I'm told that they move between Paris and Boston also, and we don't know about service in Kuwait. We're not sure how service would take place in Kuwait, but it may well be by diplomatic method, but we just don't know.
Well, I'm going to make an order for alternative service on the basis that because this is an urgent matter, it needs service to be effective speedily and efficiently, and any method other than alternative service by email is likely to result in delay, which is inappropriate when one's got an injunction and proceedings of this nature. So alternative service, fine.
I'm grateful for that.
No, I say, the order will be for 45 million, and the question as to return date, and I think I would like you to come back to me on the question of any undertaking.
Yes.
I'm going to be unavailable for a bit. I've got a funeral to go to, which is
I'm sorry.
Why we're starting early.
Yes.
So what I'm going to, the effect of this may be that the order won't be issued till tomorrow, but I don't think in the circumstances that's going to be a problem to you.
I don't think so. So
what I'm going to suggest is that you send in writing to the court and to me whatever there is to be said about fortification of undertaking.
Yes.
And so far as a return date is concerned, what are you suggesting?
I'm not sure what a court would consider appropriate in circumstances. I imagine 2 weeks. I mean, that could, of course, if the other side want slightly more time, they can come back, and we'll be flexible, as would always be the case. So that would be the 23rd of November, but we're in your hands, my lord.
Yes. All right. Well, let's work on that basis.
I'm grateful. The only other thing in the order, I mean, we've listed the assets that we've identified. That's the other major change, but otherwise everything else is in the standard form.
Yeah. Yeah.
We've put spending at $3,000 a week.
Yeah. Well, he can come back on that.
Yes.
I think that the two things I want you to come back on. One is the fortification of the undertaking, and the other is the principles that lie behind the question of enforcement in other jurisdictions.
Yes.
And if you put that in an attachment to an email or something.
Yes.
I will then look at that sometime later today. I should be in chambers this afternoon, so do you have my, I'm going to ask you to send it to my email direct in case there's delay and the courts are closed by the time you get around to doing it.
Yes.
So if you look on the 7 Kings Bench Walk website, you'll find my professional email as an arbitrator there.
Yes, we shall do that.
Okay, is that all right?
Yes, my lord. Thank you very much for your time and patience this morning. Thank you.
Okay, anything else you need to raise at this stage?
Not from my side, my lord.
No, very good.
Well, there is only my side, of course.
Well, I was going to ask the court whether there's anything that needs to be dealt with from the court's angle.
I think we're good for now. I think all we need is the order draft so we can issue it after your approval, Sir Jeremy. But aside from that, nothing on our behalf.
Thank you. I think it unlikely, therefore, that I will get back to you before your closing time in Dubai. It'll be this afternoon London time, by which time hopefully you'll be out to dinner or something.
Hopefully.
All right. Very, very good. Thank you very much, Mr. Bohr, and thank you very much for all your help. And
thank you.
I will sign out.
Thank you.
Thank you. See you soon.
Thank you very much.
Thank you, sir.
Thank you, my lord.